Hello everyone. In today's video, we are going to solve the previous year question paper. Previous year question paper of AIB 11. Okay, and this is set A, and ये conduct हुआ था 2017 में. Total 100 क्वेश्चन है इसमें और इसको सॉल्व करके देखते हैं. First question says Section 154 under IT Act is option A for filing return of income, option B for filing return with late fee, option C rectification of mistakes, option D appeal against the order passed by the ITO. Before starting before continuing the video, I'm just letting you know, if you will feel the speed is slow, then you can adjust the speed of the video accordingly. Okay, अगर slow लगे तो 1.5 या 2x पे करके इसको देख लेना, adjust कर लेना अपना according. So question number 1, section 154 under IT Act is option A for filing return of income, option B for filing return with late fee, option C rectification of mistakes, option D appeal against the order passed by the ITO. Appeal against the order passed by the ITO. Its right option is option C, which is rectification of mistakes. Section 154 under IT Act is used for basically rectification of mistakes. Question number 2, which of the following is not included in the capital asset? Which of the following is not included in the capital asset under section 2, subsection 14 of the Income Tax Act? Its right option is option C, which is both A and B. And what option we have? Option A says any stock in trade. Option B, special bearer bonds 1991 issued by central government. Option C, both A and B. Option D, none of the above. And its right option is option C, which is A and B, which is any stock in trade as well as a special bearer bond 1991 issued by central government. Question number 3, the language which is to be used in the arbitral proceedings is decided by the option A, the tribunal, option B, parties to decide by mutual understanding, option C, the petitioner, option D, the defendant. Its right option is option B, which is the parties to decide by mutual understanding. So the language which is to be used in the arbitral proceeding is decided by the parties to decide by mutual understanding. Question number 4. The arbitral proceeding shall stand terminated. The arbitral proceeding shall stand terminated. Option A, on making of the final award. Option B, by an order of the arbitral tribunal. Option C, when the parties to the dispute agree to terminate proceeding. Option D, all of the above. Its right option is option D, which is all of the above. So the arbitral proceeding will automatically terminate when the when on making of the final award, or by an order of the arbitral tribunal, or by when the parties to the dispute agree to terminate all proceedings, terminate proceedings. Okay. Question number 5. Every award of a Lok Adalat is deemed to be option A, order of district collector, order of income tax commissioner, decree of a civil court. Option D, A and B, which is order of district collector and order of income tax commissioner. Its right option is option C, which is decree of a civil court. So the award of a Lok Adalat is deemed to be decree of a civil court. Question number 6. The Arbitration and Conciliation Act 1996, Section 18 to 27 states option A, the conducting of arbitral proceedings. Option B, receipt and written communication. Option C, extent of judicial intervention. Option D, awarding final decision. Its right option is option C, option A, the conducting of arbitral proceedings. Question number 7. Provision of section 80 of CPC is binding on Option A, the High Court. Option B, the Court of Civil Judge. Option C, District Judge. Option D, all of the above. Its right option is option D, all of the above. So the provision of Section 80 of CPC is binding on all of the above. Uh, in all of these, okay. Question number 8. Temporary injunction can be granted. Temporary injunction can be granted. Option A, suo motu. Option B, ex parte. Option C, hearing both parties. Option D, none of the above. Its right option is option B, which is ex parte. Question number 9. Right to appeal is option A, natural right. Option B, inherent right. Option C, statutory right. Option D, delegated right. Its right option is option C, which is statutory right. Question number 10. The last amendment of the Indian Succession Act was made in. ऑप्शन है हमारे पास ऑप्शन ए 2000, ऑप्शन बी 2001, ऑप्शन सी 2002, ऑप्शन डी 2004. इट्स राइट ऑप्शन इज ऑप्शन सी, विच इज 2002. क्वेश्चन नंबर 11. वेट. Question number 11. Which is the correct statement? Option A. There can be a will without a codicil. Option B. There can be a codicil without a will. Option C. Every will has a codicil. Option D. A codicil precedes a will. Its right option is option A. There can be a will without a codicil. Question number 12. Question number 12. As per Section 63 of Indian Succession Act, as per Section 63 of Indian Succession Act, a will should be attested by option A, by two witnesses, option B, by two or more witnesses, option C, only one witness who is not a relative of testator, option D, none of the above. Its right option is option B, by two or more witnesses. Question number 13. Iddat under Mohammedan law refers to option A, a gift made on the occasion of marriage, option B, the right of the husband to divorce his wife, option C, attaining of puberty, option D, none of the above. Option A gift made by the occasion of marriage, option B, option A gift made by the occasion of marriage, option B, the right of the husband to divorce his wife. Option C, attaining of puberty. Option D, none of the above. Its right option is option D, none of the above. Question number 14. Under the Christian Marriage Act, the marriage registrar for any district is appointed by. The marriage registrar for any district is appointed by option A, state government. Option B, central government. Option C, clergymen of the church. Option D, high court judges. Its right option is option A, which is the state government. Question number 15. The word ombudsman is derived from option A, French administration, option B, British administration, option C, Swedish administration, option D, German administration. And its right option is option C, which is Swedish administration. Question number 16. Under section under section 3 of the Commission of Inquiry, under section 3 of the Commission of Inquiry Act 1952, an inquiry commission is appointed by option A, central government or state government, option B, Union Public Service Commission, option C, State Public Commission, option D, Supreme Court of India. Its right option is option A, which is central government or state government. So under section 3 of the Commission of Inquiry Act 1952, an inquiry commission is appointed by central government or state government. Question number 17. Information Technology Act was enacted in option A 1988, option B 1996, option C 2000, option D 2004. And its right option is option C, which is already marked, which is year 2000. Okay, so Information Technology Act was enacted in 2000. Question number 18. Government of India passed Information Technology Act in 2000 with objective. अच्छा यहाँ पे क्वेश्चन है, इसका आंसर यहाँ पे भी दिया हुआ है। हाँ, एक मार्क्स तो ऐसे ही दे दिए थे उन्होंने ना। Question number 18. Government of India passed Information Technology Act in 2000 with objective. Option A, to provide legal sanction to all transactions for e-commerce. Option B, to facilitate electronic filing of all documents to the government. Option C, to amend Indian Penal Code, Indian Evidence Act to punish the cyber crimes. Option D, all of the above. Its right option is option D, which is all of the above. Okay. So, Government of India passed Information Technology Act 2000 with objective to provide legal sanction to all transaction for e-commerce. Option B, and to facilitate electronic filing of all documents to the government, to amend Indian Penal Code, Indian Evidence Act to punish the cyber crimes. Okay. Question number 19. Right to personal liberty includes option A, right against custodial violence. Option B, right of under trials to separate them from convicted. Right of under trials to separate them from convicted. Option C, right against public hanging. Right against public hanging. Option D, all of the above. Its right option is option D, which is all of the above. Question number 20. The Supreme Commander of the Defense Force of India. The Supreme Commander of the Defense Force of India is option A, President. Option B, Prime Minister. Option C, the Defense Minister. Option D, Chief Marshal. Its right option is option A, President. So the Supreme Commander of the Defense Force of India is President. Question number 21. Retirement age of Supreme Court judge is option A 62 years, option B 60 years, option C 58 years, option D 65 years. Its right option is option D, which is 65 years. Question number 22. Criminal Procedure Code is a subject of option A concurrent list, option B state list, option C union list, option D none of the above. Its right option is option A, concurrent list. So, Criminal Procedure Code is a subject of concurrent list. Question number 23. Bailable and non-bailable offense has been defined in option A, section 2, subsection A of CRPC, option B, section 2B of CRPC, option C, 2C of CRPC, option D, section 20 of IPC. Its right option is option A, which is section 2A of CRPC. So, the bailable and non-bailable offense has been defined in section 2A of CRPC. Question number 24. Under section 21 of CRPC, special executive magistrate may be appointed by option A, central government, option B, high court, option C, Supreme Court, option D, special executive magistrate may be appointed by central government, high court, Supreme Court, or option D, state government. 24th right option is option D, which is state government. Question number 25. Police may carry out personal search on an arrested person. Police may carry out personal search on an arrested person. Option A, under section 49 CRPC, under section 50 CRPC, uh, under section 51 CRPC, option D, under section 52 of CRPC. Its right option is option C, which is under section 51 of CRPC. So on basis of section 51 of CRPC, police may carry out personal search on an of an arrested person. Question number 26. The special court, option A, not subordinate to High Court, option B, superior to High Court, option C, supplement to High Court, option D, equal to Supreme Court. Its right option is option A, not subordinate to High Court. Question number 27. The powers under section 159 of CRPC can be exercised by a magistrate. Option A, when the police decides not to investigate the case. Option B, when the investigation is still going on. Option C, both A and B. Option D, none of the above. Its right option is option A, when the police decides not to investigate the case. Question number 28. A statement recorded during investigation. A statement recorded during investigation under section 161 can be used in trial. Under section 161 can be used in trial. Option A, for contradicting the witness. Option B, for corroborating the witness. Option C, incorporating in the charge sheet. Option D, discharging the accused. Its right option is option A, for contradicting the witness. So the statement recorded during investigation under section 161 can be used in trial for contradicting the witness. Question number 29. Power of taking cognizance of offence by a magistrate of first class. Power of taking of cognizance of offence by a magistrate of first class or second class is provided. Option A, under section 173 of Criminal Procedure Code, or option B, under section 190 of Criminal Procedure Code. Option C, under section 190 of IPC, which is Indian Penal Code, or option D, none of the above. Its right option is option B, which is under section 190 of Criminal Procedure Code. So, power of taking cognizance of offence by a magistrate of first class or second class is provided under section 190 of Criminal Procedure Code. Question number 30. Additions or alteration of charges is provided in CRPC. Addition or alteration of charges is provided in CRPC. Option A, under section 214, or under section 215, or 216, or 210. Its right option is option C, which is under section 216. So under section 216, additions or alteration of charges is provided in CRPC. Under section 216, additions or alteration of charges is provided in CRPC. Question number 31. Which section of specific relief act prohibits filing a case against the government? Question number 31. Which section of a special relief act prohibits filing a case against the government? Option A, section 5, section 6, section 7, section 8. Its right option is option B, which is section 6. Section 6. Okay, so under section 6, uh, basically the section 6 of a specific relief act prohibits filing a case against the government. Question number 32. Patent Act become a law in option A 1970, option B 1975, option C 1996, option D 1966. Its right option is option A, which is 1970. So the Patent Act become a law in year 1970. Question number 33. Check bouncing cases charged under section 138 of Negotiable Instruments Act is triable by option A, Bank Tribunal, option B, Consumer Forum, option C, Magistrate Court, option D, Sessions Court. Its right option will be option C, which is Magistrate Court. Question number 34. The provision of establishing Public Service Commission is made under option A, Article 310, option B, Article 315, option C, Article 320, option D, Article 325. Its right option is option B, which is Article 315. Article 315. So the provision of establishing public service commission is made under Article section 315. Question number 35. The case Krishna Gopal versus State of MP. The Krishna Gopal versus State of MP relates to question number 35. The case Krishna Gopal versus State of MP relates to option A, water pollution, option B, air and water pollution, option C, noise and air pollution, option D, water and noise pollution. Its right option will be option C, which is noise and air pollution. Noise and air pollution. So the case Krishna Gopal versus State of MP relates to option C, which is noise and air pollution. Question number 36.